The second question, Nick, we'll dive into that one with you. It's got to do with invoices of water, a levy, and obviously the Brodie corporate statements. This question goes, can we invoice for water if it is included in the levy and not a separate item on the Brodie corporate statement? Nick?
Okay, so it's an interesting one. I've seen a couple of body corporates that do, in fact, do this. Okay, the real trick with this is generally what's expected when you're in a body corporate. There is a levy which is applied to the particular scheme, and that levy has been set during your annual general meeting of each year, and then it is attributed to each of the owners depending on their size of their particular unit within the scheme, and that determines how much of a levy you generally pay inside your scheme. Okay. And that is usually a fixed levy that goes forward for the rest of the year. Okay. Now, in circumstances of water and tenants paying for water, you are obviously entitled to charge your tenant for water that they use on the particular premises. Okay. But you have to be careful. You're not entitled, okay, to overcharge for the use of utilities on a particular premises. No one is entitled to do that. So as far as our law is concerned, that you can't make a profit out of providing services to a tenant on a particular property. And there you have to be very careful, because that means that you can charge for a utility, but you can't overcharge for that utility and derive an income or a profit out of that provision of that particular utility. And that is where body corporates that do this become quite difficult. Okay, because how do you exactly determine what the water usage is of your tenant on that particular property for any specific period? If you can get that information, and you may be able to get that information from your managing agent on the particular scheme, okay, because generally they some managing agents will have a meter reading agency that's going to go out and get these readings, during a particular month, and maybe you can get that information from your managing agent in the circumstances, and then if you've got what the charge is for your particular unit and that's what your tenant has used, fine, no problem. Put it onto your tenant's invoice on a monthly basis. But if you can't find that particular information, I would be very cautious about applying a blanket, just a number for water. Okay. Mm-hmm. If you are shortchanging yourself, I mean, that's one issue, because but you're going to have to handle the shortchanging, and there's no real consequences as a result of doing that. Okay. But the far more careful side that I would caution against is in circumstances where you perhaps charge a number and then there is an overcharging of utilities on the premises. And remember, it's very difficult to determine whether there's an under or overcharging. If your tenant has gone away for holidays over a particular period and now not used the water, in their unit, and you're still charging a blank rate, you might have a problem there, in that you are charging them for a service that you actually aren't providing to them, and there can be long-term consequences as a result of that. So look, generally when it comes to something like this, on a personal note, I have a property where this is exactly the problem. My levies are included, the water is included in a levy. What I did in that circumstance is I took that into account for my rental consideration. So when I advertised the property, I said, look, this is the rent consideration, and as a bonus, you don't actually get a separate water charge, but I took that into account for my rental. And in doing that, you escape this argument of, have you been overcharging for the actual utilities that you've supplied in the circumstances? That for me is the best way to address this sort of problem.
Absolutely. Just to add on that, interestingly enough, a lot of the guys that do the prepaid meters and the actual charging of any utilities, so they're also quite strict on overcharging. And so things like common areas, if you ask them to charge a little bit extra, so for example, we've got electricity directly to one of our apartments, but there's a common area where there's obviously a co-contribution between everyone. You have to justify this to this company, that they can justify it themselves, to say, look, there's this amount of lights. I feel that a 2% surcharge, should be charged as a contribution, and they'll assess it and come back to you. So it's just interesting. So they're quite strict when it comes to any surcharges on electricity consumption and water consumption.
Yeah,
absolutely. So thank you very much there to Nick and Bruno. A very clear guidelines on that one. And yeah, that does bring us to the end of our 2 questions and answers for today. Thank you everybody for joining us. Hope you enjoyed the 2 answers there. And then we'll be seeing you guys again next week. Thank you to the experts.
thanks guys.
Thanks so much. Cheers.